Hello, my friends. Today we discuss an interesting topic in relation to insurance laws. A lot of us take insurance with regard to medical policies as well as life insurances. Many of us go on paying premiums without sometimes getting any kind of communication from the insurance companies. But we continue because that's the norm. We go ahead and do it. Interestingly, what we presume is that our contract for insurance has been concluded because the insurance company has taken the premium, accepted the premium, and has gone on accepting the premium. Even if they have not issued any letter, even if they have issued no document to us. Sometimes it does happen. This presumption, however, is not correct. Way back in 1984, the Supreme Court of India, in a very interesting judgment, perhaps very much favored in relation to the insurance sector, what it said was that the insurance company always has a right to take time to underwrite. And as a result, till there is an overt act whereby they actually issued an acceptance letter, the contract of insurance is actually not concluded. They use a various jargons which I'm not going into, but as a result, what has happened is over the years, various courts have had to because of Article 141 follow the Supreme Court judgment, and many a person has been denied their rights. People who have died under and their family was under the presumption that yes, there was an insurance, medical policies, mediclaims, they have been denied. There have been death benefits related matters which people have got their claims denied, repudiated, only because of the fact of this judgment which said that even if there is a period of gap, the insurance company can always repudiate the contract if they have not issued that letter, they have not issued that document. They can always keep the money which they have collected from the customer into some kind of a suspense account, into any kind of other account, and they can always return back the money. If you really think about it, it's extremely inequitable. If the insurance company actually accepts it, if it accepts the money, then it should be that yes, they have already weighed in the pros and cons, they have already underwritten it, and thereafter they are taking it. Because we have to presume what was happening in 1984 is not the same thing what is happening today. Today we have a multitude of insurance companies, private sector, public sector. We have so many people taking insurance, which was not the case then. So in such a circumstance, if this law remains, and which is the law at this moment, many a person will be denied their legitimate rights. This issue again came to the fore in 2018 before the Supreme Court. Interestingly, the Supreme Court said that yes, we agree with the 1984 judgment, but that is more like a flexible formula. And in that particular case, gave relief to the insured against the insurance company. Now, the thing is, at this moment, that 1984 judgment of the Supreme Court, the ruling, that stays as the law. As the law. So be aware of the fact that when you take insurance, even if you have paid the premium, that is not a conclusion of a contract. That does not make mandatory for the insurance company to pay you at your time of need. You have to make sure that the insurance company gives you a certificate or a document of acceptance of liability. That yes, not of acceptance or a receipt of the money they have taken. An acceptance of the liability. That yes, if this happens, we will pay you. There's a difference between the two. One is only a paper indicating payment of premium and acceptance of premium. As per the law, that is not enough. What is important, however, is that they give another certificate of the insurance policy deed, which suppose, like say a LIC gives you a policy deed. That document has to be given to you. Till that document comes to you, you are actually not insured. It is just that your premium has been accepted by the insurance company and has been kept by them, and they can return it to you. It is an inequitable law. Perhaps it should be revisited and checked and changed. But as of now, this is the law, and please be wary of the same and insist upon proper documentation from your insurance agents and your insurance companies. Thank you. Take care.